They say land is just dirt, a commodity, a place to build. But for me, for my family, this isn't just land. This is 73 acres of history, sweat, and sustenance. My grandfather cleared these fields. My father taught me to drive a tractor on this very soil. Every fence post, every worn path, every gnarled oak tree tells a story. It's in my blood. It's in my children's future. So, when I say my property, it carries a weight that most city folk, most suburbanites, will never understand. It's not just a legal deed. It's an extension of who I am. We put up signs, clear as day. Private property. Nitrogen monoxide trespassing. Not because we're unfriendly, but because these acres are a working farm. There are heavy machines, livestock, fields of crops. It's dangerous for casual wanderers, and it's vital for our livelihood that we control who comes and goes. We've had the occasional lost hunter, a misguided tourist, but a polite word, a pointing finger, and they've always understood. People respect boundaries, or so I thought. The first time I saw her car, it felt like a mirage, a gleaming, obsidian black luxury SUV, utterly out of place, parked squarely in front of my main gate, not off to the side, not even pulled over on the verge, right in the middle, blocking my access to the lower fields, to the barn, to the very heart of my operation. It was like someone had erected a monument to disregard right in my driveway. I remember standing there, staring at it, my hands on my hips, a slow, cold knot forming in my stomach. It wasn't just an inconvenience. It felt like an insult, an intentional, deliberate act of defiance against the very notion of ownership. I walked around it, looking for a note, a driver, some explanation. Nothing. The windows were tinted, reflecting the bright morning sun like a dark, unblinking eye. It hummed faintly, that modern, electric hum of an expensive machine, a sound utterly alien to the quiet hum of my fields. I tried the gate, a heavy, bolted beast I'd welded myself. It wouldn't budge. My digger, the very machine that was about to become an instrument of drastic reclamation, sat idle in the distance, waiting for me to get to the fields it needed to clear. But I couldn't get it out. This car, this gleaming black box of arrogance, had paralyzed my morning. I thought, initially, it must be a mistake. Someone lost, someone pulled over in an emergency. People don't just do this. Not on private land, not where there are clear signs. That was my naivete. That was my rural, old-fashioned belief that common sense and basic respect still held sway. I would soon learn that for some, those concepts were as irrelevant as the weathered no trespassing sign itself. This wasn't just a car. It was the first volley in a war one never asked for, a war over the most fundamental right a person has, the right to their own damn land. It wasn't about the inconvenience. It was about the violation, and the violation felt personal, cutting deeper than any physical damage could. The legal concept of property rights is a cornerstone of civilized society, establishing clear ownership and the right to exclude others. When a vehicle is parked on private land without permission, it constitutes trespass to land and, potentially, trespass to chattels, the wrongful interference with another's lawful possession of personal property. If the vehicle itself is considered to be causing interference, however, the methods of enforcing these rights are where the complexities arise. While a landowner has certain self-help remedies like physically removing a trespasser or an obstructing object, these actions are strictly governed by principles of reasonableness and avoiding damage. The legal system prioritizes peaceful resolution and minimal force. The immediate challenge for a landowner in such a scenario is the disconnect between the clear violation of their rights and the often slow, bureaucratic, and financially burdensome process of legal recourse. This gap between clear right and difficult enforcement is precisely where frustrations escalate and can lead individuals to consider actions that, while emotionally justifiable, carry significant legal risks for themselves. The story of Jake, a prime example of this inherent tension, where the desire for immediate justice clashes with the cautious strictures of the law. This initial act of seemingly minor trespass sets the stage for a dramatic conflict, fueled by both legal principle and primal territorial instinct. I saw her eventually, after about an hour. A woman Karen, as I'd later come to know her, emerged from the woods further down the road, adjusting a designer scarf. She was carrying a small, fluffy dog in a pristine carrier. She looked utterly out of place, like she'd just stepped off a magazine cover and onto my dirt road. I walked over, trying to keep my voice even, my farmer's patience still intact. Ma'am, I began, gesturing to the sign and then to her vehicle. You're on private property. This isn't a public road, and you're blocking my gate. I need you to move your car. She barely glanced at me. Her eyes, magnified by expensive sunglasses perched on her head, flicked over my work clothes, my muddy boots, and then settled back on her phone. She was scrolling, completely disengaged. Oh, I'm just here for a moment, she mumbled, not even bothering to lower her voice fully, waiting for a friend. It's fine, it's fine. That phrase, it echoed in my head like a bell ringing for a false alarm. Nothing was fine. My morning was disrupted. My property was being disrespected, and she was treating it as a minor inconvenience to me, the actual landowner. I tried again, a bit more firmly this time. No, ma'am, it's not fine. This is private land. You're trespassing. I need you to move your vehicle now. She finally looked at me, a slow, irritated blink. Look, she sighed, her tone dripping with condescension. It's just a dirt patch. You don't own the whole world. My friend said this was a good spot. I'll be gone soon. Then, as if to underscore her point, she got back into her SUV, rolled up the window, and resumed her phone conversation, effectively ending our discussion. Just like that, dismissed, like I was a fly buzzing around her expensive windshield. I stood there, staring at the closed window, at the glint of the sun off her tinted glass. My blood started to simmer. It wasn't just a trespass anymore. It was an act of blatant, arrogant entitlement. She genuinely believed that her momentary convenience was more important than my property rights, my livelihood, my very claim to this land. I walked back to the farmhouse, shaking my head, muttering to myself. Mary saw my face when I came in. She didn't even need to ask. The car was still there, a black smudge on the horizon of our morning. She won't move it, will she? Mary asked, her voice quiet, already knowing the answer. No, I replied. She won't. Not until someone makes her. And that was the start of the escalation. The next day, the car was still there. And the day after that, I left polite notes, tucked under her windshield wiper. Please move your vehicle. This is private property. They disappeared. I placed a bright orange traffic cone in front of her bumper. By midday, it was lying in the ditch. It was no longer a misunderstanding. It was a silent, infuriating game of chicken, and she was clearly daring me to make the next move. The sheer audacity of it gnawed at me. My father, a man who worked this land until his dying day, would have rolled over in his grave. This wasn't just a car. It was a physical insult, a constant reminder that someone believed they were above the rules, above the very concept of ownership. Every time I drove past it to access a different part of my land, every time I saw it sitting there, pristine and arrogant, my frustration deepened. It wasn't just an inconvenience anymore. It was a violation of my peace, a constant source of stress, and a direct threat to my fundamental rights as a landowner. This scenario, a textbook case of narcissistic entitlement clashing with fundamental property rights. The Karen archetype often exhibits a profound lack of empathy and a strong belief in their inherent superiority or special deservingness. In her mind, the inconvenience of finding appropriate parking or walking a few extra steps outweighs the property owner's legitimate rights. When confronted, individuals with this level of entitlement rarely respond with understanding or apology. Instead, they often react with dismissal, annoyance, or even aggression, viewing the challenge to their behavior as a personal attack. They perceive the property owner as being unreasonable for expecting basic respect for boundaries. This dynamic is inherently provocative. The continuous, flagrant disregard for rules and warnings acts as a deliberate psychological irritant, designed to wear down the victim's patience and often, subtly, to coerce them into a reactive state. The aggressor knows that the system is slow, and they exploit this delay, pushing the boundaries further and further, essentially daring the victim to take an extreme action. This escalating pattern is not accidental. It is a calculated, if subconscious, strategy to assert dominance and control. The polite requests, the notes, the single orange cone all dismissed with the wave of a manicured hand. Her car remained, a gleaming black monument to her impenetrable sense of entitlement. It had been sitting there for a week, a full 7, minus one of my main gate being blocked, of me having to take detours, of that constant, infuriating visual reminder that my property was not truly mine. My patience, a commodity abundant as the prairie grass, was thinning. I decided to escalate my passive defense. I spent an entire morning creating a fortress of deterrence. I hammered half a dozen new, brighter private property signs into the ground along the perimeter. I bought a spool of bright orange plastic fencing and strung it across the road, creating a clear, undeniable barrier. I even arranged a semicircle of heavy, empty feed barrels, thinking no one could possibly miss such a clear, physical demarcation. My intention wasn't aggression, it was simply to make the boundary undeniable. To force her to see, I watched from the farmhouse window as she returned later that afternoon. She pulled up to my makeshift barrier, stopped, and got out of her SUV. I held my breath, hoping. She didn't hesitate. With a sigh of theatrical annoyance, she kicked aside the feed barrels, snapped the plastic fencing with a casual tug, and drove her vehicle with absolute precision into the exact same offending spot. Then she simply sat there, scrolling on her phone, as if the entire elaborate display of my boundary was nothing more than a childish tantrum. That's when I knew. This wasn't ignorance. This wasn't even carelessness. This was a deliberate act of defiance. She understood. She just didn't care. My next step was the law. They'll make her move, I told Mary, trying to sound confident. I called the local sheriff's department. The deputy who arrived was a young man named Miller, fresh-faced and earnest, but with the wary eyes of someone who'd seen too many petty disputes. He listened patiently to my story, nodding, taking notes. Then he walked over to Corinne's SUV, tapped on her window. She rolled it down a crack. I watched as she spoke, animatedly, gesturing vaguely. He listened, he nodded, and then he came back to me, shaking his head. "Mr. Peterson," he began, "she says she's just waiting for a friend, claims her car had an issue earlier, and she's not actually parking, just temporarily stopped. Says she'll be gone soon." He paused, uncomfortable, without a tow-away zone. "Permit specifically for your private road, or direct evidence of malicious damage to your property. It's essentially a civil matter. We can issue a warning for trespass, but we can't force her to move the vehicle unless she's actively committing a crime or obstructing an emergency." He handed me a piece of paper, a formal warning for trespass. I saw Corinne watch us from her car, a faint, victorious smirk playing on her lips. The warning, I knew, was as useless as my orange cones. So I got a lawyer. Marcus, a good man from the next town over, specialized in property law. He understood the sanctity of land, the frustration of these kinds of situations. He wrote her a formal cease and desist letter, citing statutes, threatening legal action for trespass, nuisance, and potential lost income from my blocked access. The letter was sent certified mail. We waited. A week later, it came back, unopened. Refused. Marcus then drafted a petition for a temporary injunction, an official court order to compel her to remove the vehicle. He explained the process: filing fees, court dates, service of process, motions, hearings. It would take weeks, maybe months, and it would cost thousands of dollars, money I needed for seeds, for equipment, for my family. All to move a car that shouldn't have been there in the first place. "The system is designed for a reason, Jake," Marcus said, seeing the desperation in my eyes. "But sometimes, it's slow and expensive. She knows that." She's exploiting the gap. Exploiting the gap. That phrase resonated with a chilling accuracy. She wasn't just parking, she was performing. She was deliberately pushing me, pushing the system, knowing that the legal wheels turned too slowly to offer me immediate relief. Her car remained a brazen challenge. Every morning, I woke up to it. Every evening, I went to bed staring at it. It became a monstrous, immovable fixture, not just on my land, but in my mind. My farm, my livelihood, my very sense of peace, was being held hostage by a woman's petty defiance and an indifferent legal system. The threats I could make were empty. The laws I could cite were slow. I felt a profound, suffocating sense of powerlessness. That frustration, that impotence, began to curdle into something else. Something darker, something more primal. The official channels had failed, and I knew, deep down, that a man can only be pushed so far before he starts looking for unconventional solutions. The fight was no longer about a car. It was about reclaiming my dignity, my control, my very right to exist unmolested on my own land. The situation Jake describes perfectly illustrates the frustrating chasm between clear property rights and the practical realities of enforcing them. While trespass is a straightforward legal concept, the burden of proving continuous, malicious intent, or demonstrating significant financial damage often falls squarely on the property owner. Law enforcement, due to limited resources and a mandate to prioritize criminal offenses, frequently categorizes such disputes as civil matters. This classification effectively shifts the responsibility from public enforcement to private litigation, placing a considerable financial and emotional strain on the victim. Furthermore, the legal avenues available, such as cease and desist letters or injunctions, are inherently slow. A temporary restraining order or injunction, designed to provide swift relief, still requires a court hearing, proper legal documentation, and service of process, all of which can take weeks. During this protracted period, the trespasser, particularly one exhibiting traits of high entitlement or passive aggression, can continue their disruptive behavior with a degree of impunity. They leverage the system's slowness as a shield, knowing that the property owner faces a dilemma: either endure the ongoing violation or expend significant time and money on a legal process that offers no immediate guarantee of resolution. This systematic gap often serves as a significant accelerant to a property owner's frustration, creating a fertile ground for extreme reactions when all reasonable legal avenues appear to lead to dead ends. The law, in its effort to be fair and deliberative, can sometimes inadvertently empower the persistent transgressor. The civil matter. The legal dead ends, the endless, infuriating, persistent presence of that black SUV on my land. It had been over a month now, a full 30 days, give or take, of that gleaming monument to entitlement parked squarely on my private access road. It wasn't just blocking a gate, it was blocking my peace. It had become a physical weight on my shoulders, an itch I couldn't scratch, a silent, mocking accusation that I wasn't man enough to protect what was mine. Every morning, I'd wake up, and the first thing I'd do was look out the window. And every morning, there it was, a black smudge on the landscape, a symbol of my frustration. It was no longer just a car. It was a physical manifestation of everything wrong with the world, a daily reminder that some people simply believed the rules didn't apply to them. It was a challenge, a personal insult. She was daring me, daring the law, daring common decency. The calls to the sheriff had stopped yielding results. They just sigh, tell me to talk to my lawyer. My lawyer, Marcus, was still talking about injunctions, about court dates months away, thousands more dollars, thousands more hours of stress, just to get a court order to move a car that shouldn't have been there in the first place. The cost, both financial and emotional, was becoming unbearable. Mary, my wife, saw it too. The lines of worrying around her eyes, the way she'd wring her hands every time she saw me staring out at that car. It was poisoning our home, our sanctuary. One afternoon, I drove past it, heading to the far side of my property to work on some fencing. And that's when I saw it. She wasn't just parked anymore. She had a picnic blanket laid out, a small cooler beside it. She was reading a book, sipping a drink, treating my private access road like her personal park. She waved at me, a dismissive, casual flick of her fingers, like she owned the place, like I was the intruder. Something snapped inside me. Not a violent, explosive snap, but a cold, quiet crack. A fuse, long burning, finally reached its end. She had escalated from merely parking to actively using my private land for her leisure, inviting friends, setting up camp. She was doing it to taunt me, to rub my face in her perceived victory. She was daring me to do something. I drove back to the barn, the blood pounding in my ears. I parked my truck and walked over to my digger. It sat there, a massive, yellow beast of steel and hydraulics, capable of moving mountains of earth. I'd spent thousands on it, hundreds of hours maintaining it. It was a tool of creation, of shaping the land, of farming. But as I stared at it, a different kind of purpose began to form in my mind. The thought wasn't rational. It wasn't legal. It was primal. It was the deep, territorial instinct of a man whose land, whose home, whose very sanity had been systematically violated. The law wasn't helping. The police couldn't, or wouldn't, make her move. My lawyer was talking about injunctions and court dates months away. Meanwhile, she was turning my property into her personal public park, mocking my claim to it. I felt a slow, burning fuse ignite within me. I kept seeing my digger, sitting there, a powerful, earth-moving beast, and I kept looking at her car, a symbol of her contempt, of her unshakable belief that she was above all rules. It wasn't about the car anymore. It was about reclaiming what was mine, by any means necessary. The months of feeling powerless, of being brushed aside, of seeing my rights trampled, it all coalesced into a grim, unyielding resolve. I ran my hand over the cold steel of the digger's arm. It was a tool, and it was about to be used for a very different purpose than digging ditches or clearing brush. The silence of the fields, which once brought me peace, now felt like a silent witness to my growing desperation. Under conditions of prolonged stress and perceived violation, particularly when formal systems of justice appear ineffective, the human psyche can enter a state of profound emotional distress. This is often exacerbated in situations involving one's home or property, which are deeply tied to an individual's identity and sense of security. The repeated, deliberate breach of boundaries, coupled with the aggressor's apparent impunity, creates what psychologists term a learned helplessness initially, followed by a powerful reactance response. The protagonist, having exhausted conventional avenues, experiences a complete breakdown in rational coping mechanisms. The act of the trespasser, utilizing the private land for leisure, as described, is not merely an inconvenience. It is a profound psychological insult. It transforms the inanimate object, the car, into a symbol of the aggressor's dominance and the victim's perceived impotence. At this stage, the desire for immediate cessation of the harm, even if extreme or legally perilous, can override the potential consequences. The individual shifts from seeking legal vindication to prioritizing primal reclamation of control. The digger becomes more than a tool. It becomes an extension of the protagonist's desperate need to enforce boundaries where the law has seemingly failed. This is a classic last straw scenario, where the accumulated emotional toll pushes an otherwise law-abiding individual to consider drastic and irreversible actions. The morning air was crisp, clear, a perfect day for farming, but I wasn't thinking about crops or livestock. I was thinking about that black SUV, still sitting there, a mocking presence on my land. Over a month of legal dead ends, of useless warnings, of blatant disrespect, a month of feeling my dignity erode, piece by piece. The decision wasn't made in anger, not entirely. It was made in cold, hard resignation. I knew the consequences. I knew this would change everything. But I also knew, with absolute certainty, that I couldn't live with that car, that woman, desecrating my land one more day. The peace of my home, my family's security, my very soul felt poisoned by her audacious disregard. I walked to the barn, every step deliberate. My eyes were fixed on the digger. It stood there, an obedient beast of steel, yellow against the green fields. I climbed into the cab. The seat was familiar, worn from years of honest work. I turned the key. The diesel engine coughed once, then roared to life, a deep, guttural sound that vibrated through the chassis, through my very bones. It wasn't just an engine starting. It felt like a declaration, a promise. I engaged the gears, the machine lurching forward. Slowly, deliberately, I drove it towards Corinne's SUV. It sat there, gleaming, arrogant, empty. She wasn't around, probably off somewhere, blissfully unaware that her reign of terror on my land was about to come to a spectacularly watery end. The sun glinted off her tinted windows. It looked like a predator, poised on my territory. I stopped the digger a few feet from her car. My hand moved to the controls, a practice motion. The hydraulic arms extended, the massive steel bucket opening like a jaw. I positioned it carefully, precisely, under her chassis. This wasn't an act of blind rage. This was an act of calculated reclamation. I wanted her to know. I wanted her to understand the depth of her trespass. With a deep breath, I engaged the hydraulics. The bucket began to lift. The metal of her expensive SUV screamed, groaned, protesting against the immense, indifferent force. Tires ripped, axles bent, glass popped. It was a cacophony of destruction, and every screech, every crunch, felt like a release. I lifted it, high into the air. It spun slightly, a grotesque ballet of metal and glass, helpless in the grasp of the machine. It looked like a toy, a trivial thing, suddenly reduced to its true scale against the power of the land itself. I turned the digger, moving the suspended vehicle towards the old, abandoned pond on the far side of the property. It was a murky, stagnant body of water, hidden by tall reeds, deep enough to swallow secrets. The water rippled gently as I approached. I paused, just for a moment, to look at the car, still suspended. It represented so much: the entitlement, the frustration, the legal dead ends, the erosion of my peace. Then, slowly, deliberately, I lowered it. The SUV hit the water with a heavy, satisfying splash. It sank quickly, gracefully, like a weary beast returning to the depths. Bubbles rose to the surface, a final exhalation. Then, silence. A different kind of silence. The silence of reclaimed territory. The silence of a boundary enforced. I sat there, in the cab of my digger, watching the ripples fade. It was done. I knew my fight wasn't over. I knew the phone calls, the lawyers, the police, they would all come. But that particular battle, for that piece of ground against that specific symbol of defiance, was unequivocally won. There was no joy, no triumph, just a profound, chilling sense of finality. My land was mine again, and the price, I knew, would be immense. But in that moment, as the last bubbles broke on the surface of the pond, I felt a terrifying calm. I had defended my sanctuary. The act described, while perhaps emotionally cathartic for the property owner, immediately elevates the situation from a civil trespass dispute to a severe criminal matter. Destroying another person's property, even if they are trespassing, carries significant legal consequences, often resulting in charges such as criminal damage to property, which can range from a misdemeanor to a felony depending on the value of the destroyed item. Given the description of a luxury SUV, this would likely fall into the felony category. Furthermore, additional charges like grand theft auto could potentially be applied, especially if intent to permanently deprive the owner of the vehicle is argued. Even if the primary intent was destruction, the concept of self-help in legal terms is extremely limited and rarely extends to the destruction of another's property. While the property owner could argue extreme provocation and a history of unaddressed trespass, this justification typically serves to mitigate sentencing rather than fully absolve guilt. The law prioritizes orderly resolution through courts, and taking such direct, destructive action is seen as a breach of that order. The immediate consequence will be law enforcement involvement, arrest, and a substantial legal battle where the property owner will transition from perceived victim to defendant. This act fundamentally changes the nature of the entire conflict. The immediate aftermath was exactly what I expected, and yet, nothing could have prepared me for the sheer chaos of it all. It felt like the entire world descended on my 73 acres. Karen, of course, was the first. She returned an hour or so after her SUV had become one with my pond. Her screams cut through the quiet afternoon, a banshee wailing, pointing wildly at the disturbed water, then at me. Then came the sirens. Not one, not two, but a whole convoy of flashing red and blue lights, painting my fields in an eerie, pulsing glow. The sheriff's department, state troopers, even some plainclothes detectives. Karen was absolutely beside herself, a furious, sobbing mess, demanding my arrest, my ruin, insisting I was a madman who had destroyed her property. I didn't resist. I stood there, by the edge of the pond, watching the last lingering bubbles rise, and simply waited. When Deputy Miller approached, his expression a mix of regret and professional duty, I just nodded. "I know, Deputy," I said, my voice surprisingly calm. "It's done. They cuffed me." The cold steel on my wrist felt almost secondary to the cold calm in my heart. As they led me away, past my wife Mary, who watched from the porch, her face a mask of fear and quiet understanding, I looked back at that empty space where Karen's car once sat. A sense of profound finality washed over me. The daily indignity, the incessant psychological warfare, it was over. The battle was moving to a new, far more dangerous front, a legal one, but that particular, infuriating siege on my land was unequivocally lifted. The precinct was a blur of questioning, detective after detective, asking the same things. Why did you do it? Did you threaten her? Were you provoked? I told them the truth, every agonizing detail of the past month, the signs, the calls to the sheriff, the ignored legal letters, the deliberate escalation of her trespass, the picnicking on my private property. My lawyer, Marcus, was there quickly, a grim, determined look on his face. He'd prepared for this. They'll argue criminal damage to property, likely a felony given the value of her car. Marcus explained, his voice low, his words heavy. Possibly even reckless endangerment, though you are careful. We'll argue extreme provocation, chronic trespass, and the failure of all conventional legal avenues. We'll argue self-help was a desperate act of last resort to reclaim your property after repeated, deliberate violation. The true storm began the next day. The story went viral. A Karen whose expensive SUV was sunk by an angry farmer using a digger. It was journalistic gold. My face, grim and tired, was plastered on local news, then national news, then exploded across social media. The headlines were a circus, digger driver's revenge, property rights pushed to extremes. HOA Karen gets her due. Even though there was no HOA, the public reaction was a bizarre mix. Some hailed me as a folk hero, a man who finally stood up to entitlement. Others condemned me as a violent criminal, a danger to society. Karen, now thoroughly enjoying her victim status, gave tearful interviews, painting me as an unhinged brute who had senselessly destroyed her only means of transportation. The legal battle was grueling. My life became a cycle of court dates, depositions, strategy meetings with Marcus. We pored over every detail, every email, every photograph of her car on my land. Marcus presented a compelling case, demonstrating the systematic nature of her trespass, the official inaction, and the severe emotional distress it caused. He brought in witnesses, my neighbors, who were sick of her too, but too afraid to act, to testify to her consistent pattern of disregard for boundaries. In the end, after weeks of agonizing legal limbo, a plea deal was reached. The prosecutor, facing immense public pressure from both sides and a strong defense from Marcus, agreed to a lesser charge of misdemeanor property damage instead of a felony. I received a significant fine and a suspended sentence, but I avoided jail time. The civil suit from Karen was far more painful. I had to pay her the full market value of her SUV. It drained a substantial portion of my savings. savings meant for my kids' education, for farm upgrades. We covered the civil settlement, but it came at a profound cost. We had to sell off a significant portion of our back 40 acres land that had been in my family for generations. Land that was meant for my children, as the for sale sign went up, hammering into the perfectly green, now meticulously maintained grass that once harbored our vehicle. I felt a deep ache. We had won my freedom, we had won the right to our peace, but we had lost a part of our legacy. Mary and I stood at the curb, watching the new owners drive up to their freshly acquired plot of my family's land. The street was quiet, the air still. The property was finally free of Karen's car, but it was also free of a piece of our history. We were free? Yes, but we were forever marked by the war fought in the quiet fields of our farm. The peace that returned was a fragile, hard-won thing, always tinged with the memory of that gleaming black SUV and the roar of my digger. The law may have found a compromise, but the price of reclaiming what was mine was paid in ways no court could truly measure. This incident, moving from a private conflict to a public spectacle, reveals several key psychological and sociological dynamics. Firstly, the public's fascination stems from the underdog versus entitled narrative, tapping into widespread frustration with perceived injustices and the powerlessness of the average person against aggressive Karens. The protagonist's extreme act, while legally problematic, functions as a vicarious catharsis for many who feel similarly encroached upon. Secondly, for the protagonist, even a legally favorable outcome, avoiding felony charges or jail, does not erase the profound trauma and financial burden. The act itself, regardless of justification, leaves a lasting psychological imprint. The loss of a portion of his ancestral land, in particular, represents a symbolic and tangible cost of the conflict, demonstrating that even a victory can come with devastating, irreversible consequences. This event will fundamentally alter his relationship with his property, his community, and his own sense of security, reinforcing a pervasive feeling of distrust in formal systems. The peace achieved is not a return to normalcy, but a new, more vigilant, and more guarded state of existence.